We're live.
Thank you for rejoining us.
Good morning. This is Rebecca Turner. Mr. Chair, did you introduce me? I'm sorry.
I did. I tried to.
Sorry. I couldn't hear very well. Good morning, everyone.
Good morning.
Rebecca Turner from the Defense General's office. Sorry to have to appear by video today. I'm recovering from COVID.
Rebecca,
Not one yet.
is there any way you can turn up your volume
Oh,
on
shoot.
your microphone?
All right, I will try. Is that better?
That's better.
All right. Yes. So we're coming from COVID and tech problems. So please let me know. It seems like video's working, but not mic. Thanks for having me back. I was here last week to talk about specifically the firearms portions of S4, and we had gone through the previous sections and didn't have time to get to the remainder. And I understand there's particular interest in talking about Section 8. I know you have a full plate today, so I thought we could jump there unless there are other places we should start. Okay. So Section 8 is pertaining to the possession of, well, it's prohibiting the possession of certain defined firearms for persons under 21 years. And I know at this point the committee has heard a lot of testimony about Bruin and including myself. So as I shared previously as to the other sections, this section also does not escape constitutional concern post-Bruin under the Second Amendment. And I'll share with you the reasons why. Again, as recollection, Bruin established now this clear test, right? There is plenty of litigation, as you've heard from me and others, as to how to understand the test specifically. But again, the U.S. Supreme Court has been clear that what is now controlling is this new test, and it starts with the plain text of the constitutional amendment, and then going into whether or not there exists history, tradition of the regulation being proposed from the time that the Second Amendment was adopted. So starting with the first step, plain text of the amendment, this section implicates sort of three obvious pieces of the Second Amendment. The people shall be permitted to have the right to possess arms. Here, you're taking a class of people, people under the age of 21, barring them completely, not licensing, not regulating certain circumstances. You're going right to the heart of it. You're banning possession, mere possession, not the carrying of, right? Not the ability to bring it, use it in certain instances. It's the mere possession. So banning certain classes of people from possessing a wide swath of arms as defined later in the section. And
Rebecca,
yes.
if I could just clarify something.
Yes.
I believe that current law, current statute already bans under 21. What this would do is get rid of the carve-outs for semi-automatic weapons. So in other words, to buy a firearm under 21 now, you can do that if you have a hunter safety course, or I believe if it's gifted to you from the family, then you can acquire one. So this doesn't there is already in place a prohibition on under 21 owning these sorts of weapons. It's eliminating the carve out circumstances where they may do so. And I feel as though when you're talking about it, you're acting as though we're acting for the first time in this area.
So Senator Bruce, thanks for that clarification. I am looking at 4020 Section A proposal, Section 8. I hope I have the latest draft, but I am just reading line on page 9, lines 1 and 2. A person under 21 of age shall not possess, and I see that as new language, and I don't have that other statute that you're referencing in hand.
Yeah.
To the extent that I'm not getting here to prepare to talk about that in contrast, but to Broome. But what this language is doing on its own, right, is establishing a categorical ban for people who are under the age of 21 from owning the definition of the assault weapons, right, later on. And so that's what I'm putting on your radar, that post Bruin, this really triggers significant direct conflict.
No, and I do understand that. I think it's crucial for people who are listening to your testimony to know that people under 21 are already prohibited from having a firearm unless they're carved out in one or two circumstances. And this would eliminate those one or two circumstances for semi-automatic weapons. So it's not approaching the under 21 class for the first time in our statutes.
And not addressing those other statutes. And okay, thank you for the clarification.
Yeah.
In terms of what the U.S. Supreme Court has done, it has never reviewed the carve-out prohibition or limiting Second Amendment rights to a class of persons based on age, period. So I wanted to put that on your radar. We also know that, so it's extraordinarily broad, is what I want the takeaway to be from my testimony, including the exception in on page 9. There's an exception for state and federal law enforcement who fall within this age category, unless they're using for legitimate law enforcement purposes, including when they're on or off duty. I wanted to make sure that the committee also saw that even how that exception is worded is very broad in terms of establishing a prohibition for people who fall within this category, who perhaps want to use the firearms lawfully for hunting, right? So the scope of this is big. It is, and so therefore I think you're going to be having to find. I would be asking, well, is there a historical tradition to regulating firearms in a similar manner involving the same class of people? Now, what I can share is that under the new test post-Bruin, there's at least one federal district court in Texas, and that decision struck down a Texas law, and it was a much narrower version. It was prohibiting 19 to 20-year-olds from public carry, not mere possession. And there the federal court applied the Bruin, determined that the use of the word people in the Second Amendment included the 19 to 20-year-old category, that it wasn't written people who have reached the age of majority. And that court looked at Heller. We have a U.S. Supreme Court decision talking about what the people means in the context of the Second Amendment. And I think that is where the concern is. And there the U.S. Supreme Court said the people is a term of art that refers to all members of the political community, not an unspecified subset. And so there I worry that this goes in direct contrast to, it's contradicted by Heller.
I'd like to ask a question, Rebecca, if I could.
Yes.
Isn't there already a federal ban on 18 under 21 owning or purchasing handguns?
I don't have that statute handy. The question I would have is not necessarily is there a regulation out there involving this, is whether it's been reviewed and upheld under Bruin, under the U.S. Supreme Court.
And we bring up court decisions from other jurisdictions. Isn't Vermont in the Second Circuit, and so only court decisions within the Second Circuit would impact until the U.S. Supreme Court makes determination?
I think
in other words, Texas, we're not with Texas, so our courts may rule completely differently in the Second Circuit than Texas.
Yes, no, I understand. It's true. This Texas decision is certainly not controlling. Any Second Circuit or previously controlling decision on the Second Amendment is now fundamentally brought into question because it's been effectively overruled by Bruin. So it would require looking at those Second Circuit decisions or other controlling circuit court decisions on firearms to see what was the analysis there. If the analysis applied the test that has now been clearly rejected by the U.S. Supreme Court, then that's no longer guiding law, right? Bruin now becomes the law, and yes, there's so many unknowns in terms of the historical tradition test and how that is playing out, right? But what is clear is now there should be a plain text analysis and then followed up with, well, if it falls within the plain text, meaning it's protected in the Second Amendment, is there a historical analog? One of the concerns I've had listening to the testimony.
Well, I mean, if you take it to its extreme, one, I guess, to get on an airplane with a loaded firearm, because there were no airplanes in 18, whatever, or 1776, 77.
And certainly that can be an extreme way of applying the analysis. I think that you've heard from others, and I want to confirm with you.
Well, I've read documents from certain individuals that have been sent to me that indicate that that would be the case, that you could, that all the laws regarding, that airplanes, trains, whatever, they weren't in a, it didn't happen. So the historical context doesn't mean anything.
No doubt that historical tradition analysis in step 2 is going to require a close look. It's going to require because we are taking modern firearms that did not exist at the time, and necessarily having to make analogies. And so it isn't going to be a clear cut. And the U.S. Supreme Court guided us and said, no, you're not looking for an identical twin, and that's not the test. You're looking for analogs. And what I urge the committee to do, because I think the test is clear, the answers as to what historical tradition exists are not clear. And yet this bill proposes not just a narrow regulation implicating Second Amendment, it is a wholesale direct banning, right? Banning possession, like the heart of the Second Amendment itself, of arms. Now, certainly we can have a separate discussion on whether the definition section, which parts of those firearms falling within the definition sections under Section 8, which are captured by the definitions or the meaning of arms under the plain text of the Second Amendment. We can have a separate.
Why wouldn't it be a violation of the Second Amendment to ban it for 12-year-olds?
Unless there is a historical analog to look at what existed at the time to ensure that children of that age were not exposed to similarly
I think there is
firearms.
There is evidence that as young as 12 years old actually fought in the revolution and were involved. And it was a different time, obviously.
Yeah, and it was absolutely a different time. And the U.S. Supreme Court urges us to not dismiss the differences out of hand. I think these questions, and I think my overall point is this: the committee has recognized the need to establish study commissions in many instances. If there was an issue that warranted a study commission prior to going forward with legislating in an area that there are so many questions on, and frankly, the key question I would want to have answered are, where is the evidence, or where are the historical analogs to the specific sections being proposed? And we haven't heard testimony about it because it requires some deeper dives on each of these sections. We can't draw in what is out there on large capacity magazines, for instance, and compare it to this one on Section 8 or the serial numbers. The Supreme Court requires analysis on each specific one. And so while I appreciate the need to do something now, I am a citizen of this country too, and I see I see the reports and nationally the events of what's going on in gun violence and deaths.
Rebecca, Senator
But
Ruth has a question.
what I'm sharing,
Rebecca,
yeah,
I appreciate the caution that you're laying down. We had the same caution from you the last time you testified. I feel like your point has been made, which is that Bruin creates uncertainty. I think you keep characterizing what we're doing as though it's the first time we're acting in this area. We have statute that was signed by the governor that limits possession for people under 21. They can only acquire a weapon in a couple of carved out ways. This goes after those carved out ways for semi-automatic weapons. I understand that's still a risk. We take your point, but I feel like we're spinning our wheels. You're just reminding us that Bruin creates uncertainty and cautioning us to study rather than legislate. Take that point as well. But I'm wondering where you're going beyond that.
well, I can focus on other parts of concerns of the bill, but certainly that is the heart of it. Is that urging study on this so that you get the answers, which is what I would want to know, which is what historical analog exists for these out there. And moving on, though, I think that there are other pieces or concerns, constitutionally at least, for the other sections involving firearms. And so I wanted to, I brought this up earlier last week, and that's in reference to bail. Right, and my concerns that the proposed language is in violation of the Vermont Constitution, particularly the bail section. And so there, I want to go back to.
Sorry, Rebecca, which section are you looking at?
Yes, I'm looking. It's section 7. It's referenced there. Section 7, page 8, lines 15 through 17. And this is about establishing that conduct constituting offense, carrying a dangerous, deadly weapon while committing a felony, shall be considered a violent act for purposes of determining bail. This also comes up in, again in on page 6, section 4. And may even appear in other places, but any time that the proposed language establishes that this conduct involving the firearm shall be considered a violent act for purposes of determining bail, that is inconsistent directly with our Constitution, and that's because the only purpose for imposing bail is to avoid risk of flight from prosecution, period. Risk of flight from prosecution. So avoiding court is the only legitimate constitutional basis a judge can impose bail. It cannot be. So
can I just interject? I'm sorry to interrupt you. I agree with the point that you're making regarding bail, and I think it was brought up that this is something that does need to get reworded. The part where it says shall be considered a violent act for the purposes of determining bail. I agree with that, and I think that the new language that we're hoping to get has to do with considering this a violent act for purposes of holding without bail. Right.
Oh, holding without bail. So there's the two. So I see you had suggested that, and I was waiting to see proposed language there. Shall be considered, and again, maybe I shouldn't take up the time if you're planning to come back to discussing this. But when you reference the hold without, you're bringing up two different subsections in the Constitution where hold withouts are permissible. And in those instances, there's a two-step process involved there, involving weight of the evidence and then further considering 7554
It may be better if you came back when we it may be better if you came back when we actually have the new language.
I'm happy to do that. And that way we can dive deeper into the subsections.
I agree it should be narrowed additionally.
I think the only I'm just going through my notes here. I think for now, I think if there are any other questions on the Second Amendment and the firearms regulations that are being proposed, I've made my points, and if there are any questions, I'm happy to take them now. Okay, thank you.
Hearing none. Thank you.
Thank you.
Hopefully you get better, and sorry to hear your illness.
Thank you.
Hopefully it's not. Mr. Lott or Dr. Lott.
Yes, thank you very much. I would like to thank Chairman Sears and also Robert Norris, who's the one who invited me to testify, and the other distinguished members of the committee to talk to you about this bill. There are a few points I'd like to make. One is that rifles are very rarely used in crime. If you look at Vermont, for example, over the last 5 years, the FBI data shows from 2017 to 2021, there were only a total of 2 murders committed with any type of rifle. Nationally, you see a similar pattern. The FBI data shows that only about 2% of murders involve any type of rifle. Obviously, assault weapons are just a category of that. If you're talking about something like mass public shootings over the last 25 years, assault weapons are rarely used there. 58% of mass public shootings involve only handguns, and 14% involve solely rifles of any variety. So obviously, purely assault weapons are just a fraction of that. And the attacks with the highest casualty rates are the ones that involve multiple weapons rather than just ones that involve rifles. There's a lot of academic research on assault weapon bans, and essentially it finds overwhelmingly no crime-reducing benefit from those bans. The largest survey of American academics was published in Regulation. If you look at academics who have published peer-reviewed research, American academics who have published peer-reviewed research on gun control, on a 1 to 10 scale, where 1 is completely ineffective and 10 is extremely effective, and so 5 is the midpoint, criminologists rated that particular regulation at a 1.7, economists at 1.57. So they're almost agreeing that it's completely ineffective. Public health people gave it a higher rating of a 4, but that's still even below the midpoint, even for them. Overall, you're talking about a rating across all the academics of something in the 2 range. There's been, as I say, a lot of research, but even research the Clinton administration funded, which put the assault weapons ban in effect, such as by Cooper and Roth in their 1997 report for the National Institute of Justice, or their follow-up report in 2004, could find no statistically significant evidence of a benefit from assault weapons ban. The National Research Council, in their report on firearms and violence, also could not point to significant evidence that the assault weapons ban reduced any type of violent crime. In 2001, federal judge in California, Roger Benitez, struck down California's assault weapons ban. He concluded that the state experts who summarized the existing research, despite numerous requests from the judge, could not provide any evidence that the prohibition reduced violent crimes such as murders, robberies, or aggravated assaults. We frequently we'll hear statements such as President Biden just in the State of the Union, which would say, when we passed the assault weapons ban, mass shootings went down. When the law expired, mass shootings tripled. What he's relying on is a unique definition from one researcher, Louis Clarivas, at the Teachers College at Columbia. And his definition inconsistently includes shootings involving drug gangs fighting over drug turf. And other parts of his definition too. The FBI, in their definition, first of all, his definition doesn't even use that consistently. But the FBI, when they define things like active shootings or mass public shootings, what they look at are shootings in public that don't involve some other type of crime like a robbery or a gang fight over drug. They also look at 4 or more people killed as compared to his. And there's a reason why they do that, and that is they want to focus on the ones that get people's attention, like a shooting at a mall or a school or a business where the whole point of the attack is simply to go and kill other people. But there's an important point here, and that is even in the quote that I mentioned before, there's no drop in attacks with assault weapons when the ban occurred. What they point to is a drop in overall mass shootings. And if you think that the assault weapons ban is going to have any effect, it's going to have an effect through reducing attacks involving so-called assault weapons. And that's not what you see. In fact, what you find is that when the ban went into effect, the percentage of attacks involving assault weapons rose. And when the ban sunset in 2004, the percent of attacks involving assault weapons fell, which is the exact opposite of what you would predict if you thought that the assault weapons ban was relevant for stopping attacks. Even the Associated Press last year, in its highly influential style book, essentially said that the term assault weapon is nonsensical. The AP said that the term, quote, conveys little meaning, end quote, and is, quote, highly politicized. They also pointed out that that these so-called assault weapons that are being talked about are not actually used by any militaries around the world. They discussed the fact that the term that's often used is military style, and what makes it, relevant there is the word style, as opposed to what actual weapons that you're talking about. We've heard this morning a reference to semi-automatic guns generally. And, if you were to ban, let's say, all semi-automatic rifles, which at least would be more logically consistent than banning ones that are, quote, military style, because there are other weapons. When you're talking about military style, there are other rifles out there that are functionally identical, firing the same bullets with the same rapidity, doing the exact same damage, that don't fall under the so-called assault weapons label there. If you were to replace semi-automatic guns with manually loaded guns, it takes much longer to go and manually put another bullet in the chamber after you fire a round. If somebody is using a gun defensively, where they have to fire multiple rounds because they're facing multiple criminals, or because they fire and miss, or because they wound the attacker but don't incapacitate them, they may not have the luxury of time for going and manually reloading the gun another time. There's a reason why about 85% of the handguns in the United States are semi-automatics, and that a similar percentage of rifles in the United States are semi-automatics. With regard to mass public shootings, I can only speculate what the motivation for carving out those who are under 21 would be. But possibly one of the motivations is with regard to mass public shootings. And if I've provided graphs in the handout that I hope you received. But if you compare under 21 to 21 to 30, 31 to 40, 41 to 50, 51 to 60, or over 60, if you're going to use that as the standard for deciding whether or not to ban the ownership of guns, you actually have a higher rate of mass public shootings for the 21 to 30 range, all the way up to the 50 years of age. If 41 to 50 is essentially the same rate of engaging in mass public shootings as those under 21, and from 21 to 40, it's actually at a higher rate. And even if you break it down by 5-year intervals, I show there that it's still much lower than many other age groups. 21 to 25 or 36 to 45 have higher rates of engaging in these mass public shootings. We just heard a little bit about the Bruin case. I've taught in law schools. Maybe I should just tell you my background for a second. I should have done this to begin with, but I've been chief economist at the United States Sentencing Commission. I was more recently senior advisor for research and statistics at the U.S. Department of Justice. I've been an academic most of my life. I've had research and teaching positions at Yale Law School, the University.
Dr. Law,
Yeah.
how long were you at the Department of Justice?
I was there for just less than 6 months. I was there at the end of 2020 and through January, most January of 2021.
Thank you.
I was at the Sentencing Commission for 2 years. And I've had positions at the Wharton Business School, was there for 4 years. And University of Chicago, I was at the University of Chicago Law School and then the University of Chicago Business School, a total of 5 years. I was at Stanford and I've been at Rice and UCLA. But just concentrating on Bruin here for a second, kind of the historical background. If you look to see early state laws around 1791 and after that for some period of time, you in fact find that most states actually required that younger people possess guns in order to be able to serve in the militia. For example, Connecticut's militia law made a requirement for those starting at age 16. Pennsylvania had a requirement for those 17 to 55 years old, quote, shall be sufficiently armed with one good musket and other firelock well fixed, end quote. In my writings there, I gave a link to historian Clayton Kramer, who has collected those things, those types of laws for other states at that time. And, rather than actually banning young people to be able to go and have guns, the states explicitly mandated that they had to be able to go and own guns. And it was for younger ages than even 18 in many cases. I'll mention one other discussion, and that's the defacing of serial numbers on guns. Obviously, there's already federal law on this that has up to a 5-year prison sentence and fines. I don't really care much one way or the other about serial numbers, but I think it's still useful to point out that they're really not the benefits that you might think from it. In theory, serial numbers on guns are useful for helping to solve crimes. In practice, that really never happens. And in theory, if a criminal leaves a gun at a crime scene, even when you have states that have registration, which would be tied to the serial numbers that are there, in theory, if a criminal leaves a gun at a crime scene and it's registered to the criminal, then you could go and trace it back to the criminal and solve the crime. In fact, crime guns are virtually never left at the crime scene. And the few times that they are left at the crime scene is because the criminal's been either killed or seriously wounded, so you've caught him anyway. And the couple times that they are left at the crime scene where that's not occurring, what you find is that the gun isn't registered to the person who committed the crime. And you look through it, there's testimony on the record for the places that have it. Hawaii's had registration and licensing of guns since 1960. They can't point to a single crime that they've been able to solve as a result of registration and licensing. Washington, D.C. has had it for decades. They can't point to a single crime. Pennsylvania has had registration of handguns since 1901. And there are court cases where the state police there have had to acknowledge that they've been unable to solve one crime as a result of having registration there in the state. So this is something that's costly. It's something that takes some resources.
I'm sorry to interrupt you. I'm stuck on something that you mentioned earlier, and I'm kind of confused here. You mentioned that serial numbers are not used in application when it comes to investigating or solving crime. Was that right? That you mentioned that?
But I didn't say they were never used. What I said was they're not used successfully to solve crimes. You will not find a gun being traced back to the criminal that's there in order to solve the crime. And I can go and give you in the written testimony I have. You will see that, in fact, in places where you even have registration attached to guns, so that a unique serial number is attached to a person's registration. Even in those cases, the police are unable to point to cases where serial numbers have been used to solve crimes.
Okay, one thing that I want to mention, though, is that as far as I'm aware, there's nothing in this bill that involves creating a registry database, and I do just have to disagree that serial numbers are not used successfully. I've used them plenty of times when I was a trooper. One of the last arrests that I made involved around $10,000 worth of firearms. All the serial numbers were documented, used to match between different incidents, and so I'm just have to voice that I disagree that the serial numbers are not useful in these circumstances.
In terms of actually linking the criminal to the crime, and I didn't say you were trying to do registration. What I said was even in states that have also had registration. And again, I don't feel strongly about this one way or the other. I know you're talking about defacing serial numbers on guns. I mean, first of all, just as an aside, it's essentially impossible to effectively remove a serial number from the gun because the stamping in the metal changes the underlying metal that's there, and it's always possible to go and pull out what the serial number is there. But I'm just saying, I can give you testimony even in places that have registration where police have been there many times. And it's, a common joke around the Department of Justice. I've talked to people that have been involved there, and, it's what you see on television shows, such as Law and Order, where registration and license and serial numbers are used to solve crimes. In practice, at least in the places that have both registration and serial numbers, haven't been effective.
Thank you, Dr. Lott. I appreciate the response. And Senator Baruth also has a follow-up.
Thank you, Dr. Lott. You went over your credentials. I'm glad that you did. We have been mailed, on the committee, we've been mailed a series of articles about you. And you might suspect they're not complimentary. And I know you've been engaged in a back and forth, as one might expect in the gun rights space. But I'm thinking of, there's a New Yorker profile of you, and it, as I say, not complimentary, but it talks about a 2003 incident of creating an online persona for yourself, and using that persona, which was purportedly a young woman who needed to use guns for her own defense, using that to support your work. It was discovered that it was you. I'm wondering if you can just give us an an explanation from your point of view of what was going on there.
Sure. Well, I mean, first of all, this reporter, Michael Spies, who did the article, was paid, I believe, $150,000 from the Trace, which is Michael Bloomberg's kind of news organization on this. And he spent something like 14 months going through my life on this, interviewing people that I hadn't talked to for decades. But you can get some idea from the funding that he got there, where he may be coming from on this issue. He never asked me about that particular incident. He didn't go and use any of the times that I've talked about that multiple times. What had happened was, after my research came out in 1998, I got a number of death threats. And I, at the urging of some other academics, I engaged in internet chat rooms where I would go and use my own name for a while. What happened, though, is that people would come in off the street to continue those discussions afterwards. And to put it mildly, these were not the most pleasant circumstances, okay, when they would come in. I had, my family had set up an email address for my 4 sons. And it involved the first 2 letters of each of their names, Maryrosh. And it was an email address and an account that was essentially accessible by anybody in my family. So I used that. The one reference, the one thing that goes and talks about it actually being a woman was not myself who posted that on the internet. You will not see any other discussion other than that one. And I talked to them after I saw that they had posted that, or a while afterwards, when I realized what had happened there. And they did not use it again after that point. But anything that I put up using that email address was essentially so that I didn't, in fact, you know, I don't know if you know kind of these old internet chat rooms, but I would say 95% or so of the people, even the other people who are obviously academics, weren't using their actual names on it. And I used my name for a while, but it was only when I actually had 2 people come in off the street and were very threatening in terms of continuing conversations that I started to use that other email address that was there.
Okay, and I appreciate that. I'm an academic myself. I do wonder why other academics would have advised you to go into internet chat rooms to do what you're doing.
Well,
But
David Friedman,
yeah,
Milton Friedman's son, was one person who's done that. And he just said that it'd be useful to kind of, because a lot of academics were participating in that, just to go and be able to go and answer their questions on things.
Yeah.
And in addition, as soon as I was asked if I was the one who was using that email address, I immediately, within minutes, acknowledged that I was doing it. In fact, in many of my posts, were just cutting and pasting from other things that I had written in responses to people's questions that were there. So other than just trying to avoid kind of kooky people going and causing problems, I really didn't go out of my way in any way to hide. As soon as I was asked, because what happened was I was using the IP address that was associated with the account there was what they call dynamic IP address. So it was constantly changing. And the only thing that somebody could find was that the email address, the IP was associated with someplace in southeastern Pennsylvania. And so and I was spending part of my time in southeastern part Pennsylvania, part of my time in Washington, D.C. And when I was asked about it, because they said they couldn't figure out for sure who was it, even though I didn't have to, I immediately said I was the one who was using the email address.
thank you very much.
And I put that out. I would have been happy to talk to Michael Spies about it, but he never asked me any questions about that when he was writing up his New York article.
Thank you. You're welcome to continue your testimony if you have anything else.
No, I'm pretty much done on this stuff, but I'm happy to answer any questions that you guys have. I mean, the bottom line, I think, is pretty clear with regard to focusing on assault weapons per se. Pretty clear with regard to the research that's there and what academics overwhelmingly who've worked on this issue think in terms of reducing crime. If you're doing it for trying to concern about mass public shootings, purely rifles of any type are rarely used, and I'm not sure why you would use that to single out people who are under 21 when you actually have higher rates of mass public shootings involving older age groups.
And I have one quick question. Thanks for being here, Dr. Lott. Senator Bob Norris.
Thank you. Thank you for inviting me.
Yes, we here in Montpelier, as a body as a whole, have a couple of distinctions. One is we need to, what I believe is work in the best interests of our constituents, whether it's safety or whatever else, along with trying to not preserve, but actually keep intact the Second Amendment of the Constitution. Now, having said that, I have concerns in both areas, obviously, but in your opinion only, and I'm not asking for statistics or whatever else, is there a clear distinction between gun laws and gun control? And if there is anything such as gun control that exists, what would that possibly look like in your opinion?
You're asking me what types of gun laws I'd like to have, or you're asking, I'm not sure I understand the last part of your question.
All right, let me rephrase it. Are gun laws ultimately gun control? Going to lead to gun control is what I'm looking for.
Right. Well, I mean, I suppose it's probably hard to think of a distinction between those two. I mean, there's going to be certain laws that impose relatively minor costs on people. And there's going to be others that are going to be imposing a lot more, but I assume it's probably a matter of degree rather than of type.
Okay, so in reference to what's referred to as gun control, with the number of firearms we have in and throughout the United States, more importantly, Vermont is what I'm really concerned about. Obviously, is there such a thing as gun control, you believe?
I mean, do I support gun control or whatever? But I mean, look.
I'm not asking if you support it or not, Doctor. I'm simply asking, like using Australia as, for instance, and many other countries who just have banned them and they're purchasing them back, they're turning them into whatever else. Is that a workable solution, do you feel?
I don't think it's going to reduce crime. Look, let me give you a simple example. If guns on net are bad, you would think banning guns would reduce murder rates or homicide rates. And yet every single place in the world that's banned either all guns or all handguns has seen an increase in murder rates, often very large 3-fold, even 7-fold increases immediately after the bans have gone into effect. You'd think out of randomness, one time you would see murder rates go down or at least even stay the same. Americans are familiar with what happened in Washington, D.C. and Chicago with the increases in murder rates and violent crime rates that occurred after their handgun bans. Gun control advocates will say that those were unfair tests because people were still able to go and obtain guns from the rest of Illinois or Indiana or from Maryland to Virginia. Thing is, that doesn't really explain why murder rates went up. It may explain why it didn't go down as they were initially predicted that they were going to do. But you see huge increases, and you see increases even in island nations, whether it's Jamaica or the Republic of Ireland or the UK, after they've had various types of gun bans being put into effect. And there's a simple reason for that. And this applies to gun control generally, not just with bans. And that is when you pass a law, you have to be careful that it's not just primarily the most law-abiding good citizens who obey the rules. Because if you have a ban and it's the most law-abiding good citizens who turn in their guns and are disarmed, you actually, you may take some guns away from criminals, but you actually make it easier than for criminals to go and commit crimes. Let me give you one.
Just for the purposes of time, do you have any other questions?
No, I'm all set. Thank you.
I saw Senator Sears
I do.
a while ago, and then Senator Bruce, and then I also have a question too.
Sure.
My question has to do with, first of all, thank you for being here, but I wanted to give you a little history of the bill. This bill is designed to deal with the problem in Vermont that we've recently been having with young people, particularly young people, coming here from other states, selling drugs. And in doing that, they frequently have traded firearms for drugs because Vermont is a very open state in terms of obtaining firearms. So they find somebody to make what's called a straw purchase, and that's the reason for that language. Our local law enforcement, particularly in my neck of the woods, Bennington County, has seen a huge increase in the use of firearms and actually shooting, and we've had a couple of murders, which is rare for this part of Vermont and the southeastern corner, southwestern corner, excuse me. And so that's the genesis of the bill. But my question is, what we've tried to do in this committee over the years is try to identify perhaps people that shouldn't possess firearms. Fugitives from justice, for example. It's in the bill because we left that off. Domestic violence abusers, and people who are a danger to themselves or others through a red flag law. So those are the types of activities we've normally undertaken. There's been some other bills that have passed dealing with firearms that I haven't supported personally, but I've always supported efforts to reduce the number who can possess.
Right.
I wonder if you could comment on those types, given your recent your comment regarding taking away from criminals.
Right. Sure. No, I think that's extremely important what you're trying to do there. Look, a major source across the whole country of illegal drugs are guns are drug dealers. Drug dealers, it's not like a drug dealer can go to the police and say, this other gang stole my drugs. Can you help us get them back? They have to essentially go set up their own little militaries in order to protect that very valuable property that they have. And if they can go, so they're going to have guns. And if they can go and make money selling drugs or selling guns, they're going to do that. You could look at a country like Mexico, for example, which has had only one gun store in the country since 1972, run by the military. The most powerful gun that you've been able to buy since 1972 legally in Mexico is a 22 caliber short round bolt action rifle. That's not the gun that drug gangs use there. The murder rate in Mexico has more than doubled since the 1972 law went into effect. They actually in recent years have had a murder rate that's been as high as 6 times higher than the murder rate that we've had in the United States. The bottom line in the discussion for both the United States and Mexico as an example is how difficult it is to go and stop drug gangs from getting a hold of illegal drugs. And similarly, how difficult it is, you're going to be just as successful, I think, in stopping them from being able to go and get a hold of guns. If I could go and click my fingers right now and cause all guns in the United States to disappear and all illegal drugs, how long do you think it would be before illegal drugs started coming back into the United States? It would be 20 minutes if you're in El Paso. How long would it be until they bring in the weapons that they would use to go and protect that valuable property? And just to give you an example how important this is, we recently came out with a study pointing out how incredibly concentrated murders are in the United States. 1% of the counties in the United States account for 42% of the murders, okay? The worst 5% of the counties account for 73% of the murders. Over half the counties in the United States have 0 murders, and another 20%, almost 20%, have 1 murder. So 70% of the counties in the United States have 0 or 1 murder, and you have 73% with, or 5% with 73% of the murders. And the thing is, if you look at those counties, let's say the 1% worst counties that have this huge share of the murders, even in those counties, the murders are extremely heavily concentrated. Almost 2/3 of their murders occur within 10-block areas within those counties. It's, you know, obviously Vermont isn't one of these places that we're talking about here, but it's the reason why it's in those areas and so heavily concentrated is that those are the areas that you have the worst drug gang problems in the United States. And so the problem that you're going to have to deal with in order to stop you know, drug dealers and drug gangs from going and trafficking in guns is going to have to deal with getting rid of the profits that are there for selling illegal drugs. Because until you are able to go and do that, you're going to get both the illegal drugs and the weapons that they're going to have a huge incentive for going and obtaining. And you see the same pattern with alcohol prohibition in the United States. You know, most people don't know this, but probably the highest murder rate that we ever had in the United States was in 1932, which was the last year of prohibition. Within 2 years after prohibition had ended in the United States, the murder rate had fallen by about 60%. And you had the same type of situation there. You know, the mob was fighting against other mobs in order to try to control the sale of alcohol in different cities that you had. And so they had to have weapons in order to protect the valuable property that they had. And so, I mean, that's, I understand what you're saying completely. But the issue that you still have there is that if you have this prohibition, not only are you going to make it so that it's not going to affect a lot of these drug gangs very much, because as I mentioned, how difficult it is to stop them from getting either the illegal drugs, and you know how hard police and law enforcement has tried to stop them from getting illegal drugs to go and sell over the decades. But not only do you have that, but you also have the situation where there's law-abiding citizens who are the ones who are going to be obeying the law and are going to be disarmed and are not going to have, you know, these semi-automatic guns in order to go and protect themselves. So if you have a woman who's being stalked or threatened in some way, she's going to be disarmed and not going to be able to go and defend herself as well.
Oh, sorry, Senator Sears, do you have more?
No, my internet is unstable, so I haven't had my video on.
Okay, I hope I answered your question, sir.
Yes, you did. Thank you.
Dr. Lab, just a quick question. I know you had mentioned some island countries, and this is going back to some earlier testimony. You mentioned some island countries, and despite the bans, there was a between 3 to 7-fold increase in homicides, I believe you said afterwards.
Well, it depends on the country, but if you're talking about the Republic of Ireland or you're talking about Jamaica, there was those types of increases. If you're talking about the United Kingdom, after their January 1997 handgun ban, over the next 8 years, there was a 50% increase in the homicide rate.
So specifically for Ireland and Jamaica, you know, I'm curious, you know, if you factored in the fact that they've both been involved in a civil war for, I mean, in Ireland's case, almost 800 years, Jamaica, 1950s or 1940s. Do you take into consideration the civil wars that might be contributing to these?
Yeah, well, I mean, there obviously were years afterwards where you had political violence that occurred in Jamaica, but even if you remove those particular years, you see an immediate increase in homicides that occurred right after the ban went into effect. And it's still, you know, more than twice as high afterwards, even when you remove the years that they had political violence that was occurring there. A lot of it was just drug gang violence that they had. And that's dealing with the types of issues that Senator Sears was just asking about. With regard to Ireland, we're talking about the Republic of Ireland, not Northern Ireland. The Republic of Ireland was not directly involved in the type of religious warfare between the Catholics and the Protestants that Northern Ireland was involved with. And the Republic of Ireland hasn't had the type of political violence that Northern Ireland had. And yet you see immediately right after the gun ban went into effect in the 70s, an immediate huge increase in homicides in the country.
So, all right, sounds good, thank you.
Thank you.
Senator Sears, do you have it? I don't think senators.
I think, are there any, I don't have any other questions. Thank you for joining us, Dr. Lott.
I greatly appreciate
Is
it.
it doctor? I'm sorry,
Yeah, I have a PhD in economics.
Okay, well, good. I'm glad I got it. I frequently have promoted or demoted police officers from their ranks.
Okay. Well, I appreciate your conscientiousness on that. I appreciate it.
Thank you, Dr. Lott.
Okay, thank you very much for your time. And I'm more than happy to answer any follow-up questions. On the write-up that I gave you, my email address should be there on the front of it, and you feel free to contact me if you have any further questions. Thank you.
Senator Sears, did you want to move on to Eric or?
Yeah, I think it'd be a good idea, but just a brief conversation, then take a break, because I think we want to get on to the confirmation of Jennifer, Judge. Eric, do you have Eric and I have had some conversations about S4 and looking at some of the changes. And one of those conversations is about the youthful offender and how to, waiting for Marshall Paul and Erica Mathage on the ping pong, which has been described as going from one court to the other, and then taking more time than should be to try to get cases resolved, and how to, as we look at the youthful offender, we're in the midst of working on that dilemma, as well as how do we make sure that if you're under 18 or under now, or 19 and under next year, or whenever we set that date, assuming July 1st of this year, the 19-year-olds came in, if we don't extend it here in this bill, another 2 years as requested, or a year, whatever we come up with, how we can make sure that they can go to family court as juveniles as well. So that is going to take some drafting skill, which Eric has, but take some time. But Eric, do you want to fill in on any other areas that we've been discussing? We've obviously discussed the held without bail, but only for certain felonies, not every felony.
Right. There were a few instances where I think the committee will remember that, I think it was even discussed this morning, it was alluded to that there might be some new language coming with respect to the several instances where the bill proposes to have certain criminal offenses be deemed violent offenses for purposes of the bail statute. Does that sort of refresh everybody's recollection a little bit? So the idea there, I think, has been proposed earlier, is to have a different way to phrase that, and it would be something along the lines of if we're just to use the straw purchasing statute as an example, conduct constituting the offense of straw purchasing shall be considered a violent act for the purposes of determining whether a person is eligible for bail. So that's different. So it's not, it's making clear that the court still has to make that determination, and then cross-reference it under section 7553A title. Because there is a specific statutory section that deals with that, lists a number of criteria that the court has to consider when it's and as Attorney Turner mentioned, there are some constitutional requirements that overlay that, but the statute is existing with the intent to conform what the Constitution requires. So I was going to pass this out, but since you're not here, Senator Sears, we could hold off on this until whenever we do the full walkthrough. I was just going to pass out the existing statute so people could look at it and see how the proposed new language would interplay with that. But I'm not sure the timing this morning or whether you, how long we're going to, or whether you.
Well, I'd like to take a break at 10:30 in order to get us back by 11:15 to take up the confirmation.
Right. So we have a few minutes, then I might as well pass it out then. Does that make sense?
Yeah, yeah.
Senator, pass this to you first. Thank you. Thank you.
You want to email it to me, I'll post it?
I don't actually have it electronically.
Maybe after the meeting.
Sure. Maybe now would be a good time to. So, Senator Sears, I had started, it's certainly a work in progress. It's sort of a redraft with some new language for various parts of what the committee actually discussed earlier in the week, and which you and I discussed as well. Is that something we should start to look at now in the next few minutes?
Well, I think if we give it out now, people can comment on it. It gives more time. And it's only a few sections, so it's not the whole bill.
No, it hasn't even.
Yeah. I mean, if something's not in there, it doesn't mean we took it out of the bill. For example, anything to do with, the under 18 and nothing's been done, under 21, nothing's been done there. Nothing's changed. It's just, we're redrafting section by section.
Right. So it's just a little, sort of really just the beginning part of it.
Yeah, it's not, I'm just trying to get the process moving. I'm not trying to take anything out without discussing it with the committee.
Right. So in that case.
Or add anything in.
Right.
That matter.
Okay, it's not too sorry. Thank you. So I'm passing it around now, Senator Sears, so this, and you'll see with, in some yellow highlights is where there's some possible.
Well, is that on the website? So I can, as I don't have a copy, I didn't bring a copy with me, so.
Peggy's posting it right now.
I don't have it. If Peggy just emails it to me, I'm fine with that.
I can send it to you. I'll send it to you. Send it to you.
Okay, thank you.
I'm posting it right now also.
So I emailed it to you, Senator Sears, so why don't you let me know when you get it, and then we can take a look at it. Does that make sense?
Yeah,
Let me see how fast it will might get a little bit faster. Yeah, Senator Sears, if you refresh, I just posted it.
oh, on the web page.
Yep, it's on the committee page. If you refresh, you should see it.
Okay. Draft 1.1. Thank you.
So you have it, Senator Sears?
Yes.
Okay.
Yep.
All right, so again, this is, it's.
The first highlighted,
Right, so this is dealing with, and let me stress that it's an understatement to say this is a work in progress. This is just what we have, ideas so far that the committee has thought about possible new language, certainly fully open to whatever additional alternate suggestions people have. So section 2 though is where section 2 have, section 2 and 3 actually are connected. Remember, these are the pieces about permitting a dwelling house or a building that a person owns or is in control of to be used for certain crimes. Section 1 is the existing law on permitting dispensing or selling regulated drugs in a dwelling. So there are a couple of changes here, or at least a couple of items noted. You remember there's been some discussion in the committee about whether the fine amounts are appropriate for these offenses. So in the bill, you remember that the proposal was to go from the existing $1,000 fine, this is for permitting your dwelling to be used for selling regulated drugs. The $100,000 fine that's in the bill, it's open for discussion. What I put next to it, just so you can see it, what is the federal fine for that? Just so you have that for a point of reference. The federal fine is much higher.
And I'm wondering if I can check your memory, Eric. My memory of that section was that some members of the committee thought moving from 1,000 to 100,000 was too big a jump. But the options that are there now are higher.
Yes, and I was gonna point out that other options, I think that I recall the committee talked about were 50 possibly, or 15, were two numbers that I heard possibly floating around. So yeah, the federal one was just for point of reference.
I see, okay.
Yeah. But yes, and to the extent that there's consensus on what a number might be now, I can certainly jot that down.
Consensus, I'm not sure.
I don't know if there was consensus other than that we kind of felt it's too high.
Yeah, I don't think we have reached the number.
Yeah.
Right.
True, I mean,
10 to 15 seems fine.
of course, we'll do what they want anyway, so.
10,
10.
Seems reasonable to me.
Senator Sears, 10,000 instead of 1,000?
I would, I'm of the higher nature, but 25,000 would be sufficient.
15?
It's 0 to 20.
Do I hear it? That's fine.
I just feel a little bit like we're at an auction.
So we're suggesting 15 back?
Okay,
I thought we were gonna get 20 there.
17, 5.
but to be consistent, then I'm okay with 15.
And so the second piece of that, of that same section, same highlighted, so it's top of page 3 in my version, is this, again, the notion the committee had been talking about of wanting to make sure that there was essentially, you might call it an off-ramp or an affirmative step that a landlord or property owner could take to avoid liability, criminal liability under the statute, if they were to take some affirmative step. And so that's a first attempt to draft some language to address that concept. So you see that it sets out two circumstances under which it wouldn't be a violation. So if the person owns or controls a dwelling, they can do one of two things to take action to, actually, I'm going to misspoke. It's phrased more broadly than that. It says if the person takes action to address the unlawful activity, including, so that's not limited to. The statutes in Vermont have a separate section in Title I, which has to do with the construction of statutes, which says the word including is always read as if it has the words but not limited to afterward. So anytime you see that word, that's why if you're working on with one of the attorneys from our office and you put but not limited to in it, they will mention to you that that's not necessary because it's already in Title I. So that means including but not limiting to, and it identifies two possible ways that the property owner could address the unlawful activity. Those are reporting the unlawful activity to law enforcement or initiating eviction proceedings. But there might be other ways that the person could address it that a court could conceivably find would operate as a way to shield the property owner from criminal liability. So move on from there, Senator Sears, or is there any comments on that?
Yeah, unless there's questions.
So the next section is similar to this one in the sense that it's again about the dwelling house or the building and the owner or person in control allowing it to be used for certain offenses. So there's a couple of things going on here. A couple are the same as what we just looked at. A couple are a little different. The one is the narrowing from dangerous weapon to firearm. So in other words, it wouldn't apply. This is assuming, actually, maybe I should back up a little bit. I think there was at first a conversation of whether or not both of these offenses should be included at all. This isn't highlighted here, but I remember the committee talking about, okay, do you want to have both human trafficking and carrying a weapon while committing a felony be subject to this criminal penalty for the property owner or landlord? Or do you want to, I think there's even the possibility of striking the section entirely was discussed. And then the other option of, well, what if we struck subdivision 2 and just kept it for human trafficking? So I think those were kind of the possibilities that I recall the committee discussing.
That is certainly my recollection, just it would be difficult for a landlord to know, like this is now the third hand, it's not that I'm doing it, it's that someone might be doing it. So that is where I thought we sort of landed, was to keep trafficking, eliminate the carrying a firearm while committing a felony knowledge.
And we, as I remember, we admitted that it was a little clunky, that we've got it in two sections, but there were reasons not to put the two together. So I agree with Senator Buhovsky. I think if there was consensus, it was around keeping human trafficking and eliminating subsection 2.
Great.
Senator Sears, is that your memory?
What are we eliminating?
On page 3, lines 17 and 18.
Line 17 and 18?
Yeah.
On page 3.
Yeah.
Yes, that's fine.
All right. Discuss the dangerous weapon or firearm distinction. And actually, it may be that since this would now be limited to a human trafficking related offense, that I'll look at this, but it might be you'd want to put this new statute in the human trafficking chapter. Might make more sense.
Yeah.
Yeah.
So change, fine amount again, I think was 15K was what we had agreed on, right? Over on the next page, for folks, again, same language about the off-ramp or the ability of the property owner to take affirmative steps not to be subject to liability. That brings us to the serial number provision. There's been some discussion of this, I think not just today, but other times during the week as well, about that comparable federal offense, which there is for defacing the firearm serial number. I don't know whether there had been thought about changing the fine on line 12, $100,000 for the defacing offense. I think it sort of had been broached. I'm not sure where the committee had landed on that. That was one where I had some trouble tracking down what the actual federal fine was for the comparable offense, but with Chris's able-bodied assistance, we may be able to find that for you. Thank you.
That's right.
I thought it was higher.
Yeah, I'm not sure what it is for this year number. I'm really not. It's the federal statutes, the quick firearm statutes that were on the fine piece are not a model of clarity.
Well, I mean, it was just a recent case. There was $16,000 in cash in a bag, along with with drugs and firearms. I don't know if any of the firearms had been defaced or straw purchased, but recently that had to do with a murder case. I mean, 16,000, there's a lot of money there. We were just discussing the drug industry and the cartels and the gangs, etc., and the amount of money that they have. So that's why initially drafting the bill was at 100,000. It's up to, it isn't necessarily going to be 100,000, but it gives the ability to set the fine at a level anywhere between $0 and $100,000.
I mean, 100,000 seems like a lot, and we did just lower the potential fine for landlords to 15. So it seems like a lot, particularly now when we're dealing with an individual
Drug dealer.
Yeah, I mean, not necessarily. We don't know that this person who has defaced a serial number is also dealing drugs. I don't know, it seems like a lot to me, especially just given some of the data there is around the people. I know that a lot of what we've been talking about is gang activity, and a lot of what we've been talking about is young people involved in that, and generally speaking, well-resourced young people don't find themselves in those positions. And so I just want to be, it seems high to me.
I guess in the last discussion, it was the indirect nature of it that had me wanting to lower the penalty. So this one doesn't, I agree it's high, but it doesn't seem out of line in the same way, because this is the person's actually knowing or should have known about the case.
But why does that justify having it be so high?
Well, I mean, in the other case, it was a knowledge of something that someone else was doing. And in this one, it's what they're doing. I'm not saying that's justification for it being so high. I just don't feel it's, I mean, to be clear, I'm not really firm on lower or higher. I just don't feel the motivation here that I did in the last.
How does it line up with fines associated with some of our other current firearm statutes?
Well, most of the other firearm statutes, I shouldn't say most, the misdemeanors, so this is about.
Right.
Misdemeanors are usually, 1 or 2 years and $1,000.
Okay.
For felony ones, that's a good question. Let's see if we can see what on the other felonies in the firearm statute.
And Eric, off the top of your head, do you happen to know what the highest fine for any crime is in our state?
No.
Okay.
What a drug, maybe what, I think we can come back to this next week. In the meantime, Eric, let's take a look at what the fines are for trafficking drugs.
All right, just the first one I saw, just so you know, for the first firearms felony I came to was carrying a dangerous weapon with the intent to injure another person. The felony offense is 10 years, $25,000. Just as one point of reference.
Maybe what are the drug trafficking?
Drug trafficking, sure, I can look at those.
Yeah, and we can discuss this. I'm open to lowering it. That's what the committee wants to do. But I think I make the point again, it's between 0 and that amount. And the tremendous amounts of money that some people have been caught with recently is one of the reasons why I put it at 100,000 and introducing the bill. So anyway, why don't we take a break until 1:15, and I'll try to stabilize my internet